For the record, this matter is before the court on the defendant files motion to modify custody and parenting time. Attorney Stephen Hyder is present with the plaintiff, Caitlin Mackenzie. Good morning, Mr. Hyder. The parties have met with Ms. Brown from the front of the court, who has provided the court with the following detailed recommendation. The recommendation is that the parties shall rotate the following holidays: spring break, Thanksgiving, and Christmas. Fathers shall have Thanksgiving and Christmas one on even years, and spring break and Christmas two on odd years. Spring break consists of the day school gets out until the Saturday before school resumes. Thanksgiving consists of Wednesday after school until Sunday afternoon. Christmas 1 consists of the day school gets out for winter break until the following Saturday. Christmas 2 follows Christmas 1 until the Saturday before school resumes. It's further recommended that the mother shall comply with the CPS safety plan in place and provide a copy to the defense attorney forthwith. And further, that mother's phone calls, the child's phone calls with both parents shall not be on speakerphone. And defendant's motion to modify custody is withdrawn. Is this recommendation agreeable with your client this morning, Ms. Glaza?
Yes, Your Honor, that is all accurate.
Thank you. Mr. Hyder, is this recommendation good with your client this morning?
Yes, Judge, it is. Thank you.
All right. Well, the prior orders will continue. In other words, the defendant file still has 6 weeks pending time in Montana. That will continue, correct?
Yes.
We're just simply clarifying these holidays that reference in this recommendation. The second question the court had, Mr. Hyder, you have a copy of the CPS plan. You'll provide that to Ms. Glaza this morning. Is that correct?
Yes, Judge. Yes, Judge. My client is indicating so, yes.
Okay. There's an allegation of consumption of alcohol while the child was in the car. Is there any pending criminal charge?
Not at this time, Judge. We do anticipate a DUI coming down, but no other charges besides a DUI. But they're waiting for the BAC to come back from the state.
Okay, and you're aware of that, Ms. Glaza?
We are, Your Honor.
I'm sure you can keep tabs on that. And does the court need to order that neither party shall consume alcohol while transporting the child?
I would like that order. I would think that would be an obvious thing, but
should be obvious. But the court will order just add a sentence, Ms. Broward, to this recommendation that neither party shall consume alcohol while transporting the minor child. It should be a given, but the court will order that. Neither party shall consume alcohol prior to transporting the minor child. What about the consumption of alcohol during parenting time or prior to parenting time? And is that an issue?
Your Honor, I haven't seen the CPS report, but I believe there's no alcohol consumption allowed. I believe she's required to remain sober. So if we could have an order that there would be no consumption of alcohol during parenting time.
Any objection, Mr. Hyder? That would apply to both sides?
Fine. That's fine, Judge. There's no objection.
So, neither party shall consume alcohol prior to transporting the children or prior to or during parenting time. Apply to both parties. So we'll just add that sentence. If you could, Ms. Broward, and with that, the court will adopt the recommendation as so amended, and a copy will be mailed to counsel. That will conclude this matter. If there's other issues, Ms. Glaze, you can always petition the court for further relief.
Thank you, Your Honor.
All right, that will conclude this matter. Everyone can zoom out. Have a good rest of the day.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
For the record, this matter is before the court for the purpose of reviewing parenting time, as well as the defendant mother's motion to change domicile to Seattle, Oregon. This hearing is being conducted via Zoom. Present is Attorney Ron Bruce, representing and present with the plaintiff father, Zachary Hyatt, and the defendant mother, Delana Denard, is also present. Good morning, everyone.
Good morning, Your Honor.
Good morning.
The parties have conferred at length with Ms. Pratt from the front of the court, who's provided the court with fine recommendation. First of all, that the plaintiff mother's motion to change domicile be denied. And the court would agree with that recommendation, Ms. Denard, because in your motion, you've made no allegations that this move will improve the quality of life for the minor child. So you may want to consult an attorney on that. You can always file another motion, but again, your motion is inadequate from a legal standpoint to get past that threshold that you must prove by preponderance of evidence that the move will improve the quality of life for the child. So the recommendation is that the motion to modify change domicile be denied. Further, it's recommended that with respect to parenting time, that father shall have parenting time every other weekend, Friday at 5 until Sunday at 5, as well as every Wednesday from 4 p.m. to 7 p.m. That is the recommendation. Mr. Bruce, is this
Yes, Judge, my client is agreeable with all that. He would just request that the court adopt the friend of the court holiday schedule, and he does have some makeup days. He basically got married last week. The ceremony is next week. He would like to use some of his makeup time.
was that discussed with Ms. LaPrade?
No.
Okay, I'm gonna put it back with Ms. LaPrade. I'm gonna leave in about 15 minutes, so it's got to be a quick discussion. If you want us to make up parenting time, Mr. Bruce, I understand it was reserved previously, but it's got to be addressed.
Understood.
We've got other matters that are backing up here. Yes, we can certainly put in this recommendation that the fallback is if parties cannot agree on holidays, the friend of the court holiday schedule will be adopted. So we can provide for that in this order. If parties cannot agree on holiday parenting time, the friend of the court holiday schedule shall apply. Mr. Pratt, can you take a few minutes to talk with the parties about Mr. Bruce's now request for, something for next weekend?
Yes.
All right, put your bed in the breakout room. Record this matter is before the court on the defendant to file his objection to a referee recommended order modifying parenting time. Two of you have confirmed with the front of the court this morning. The front of the court has provided the court fine recommendation that the referee recommended be adopted but modified. Namely, the party shall exchange a minor child at the Speedway gas station on Plymouth Road in Ann Arbor. And the exchange times will be Fridays at 5 p.m. and Sunday at 5 p.m. The balance of the recommended order would be adopted as an order of the court, namely summers would be week on, week off parenting time. We've clarified where the exchanges will occur in Ann Arbor, or actually, I'm sorry, in Ann Arbor on Plymouth Road. Mr. Chapman, do you have any objection to the court adopting this recommendation this morning?
No, I do not. My only question is so for Miss Regan, who is going to be picking up and dropping off our child? It's a legitimate question. Miss Regan will not be able to be there for the exchanges?
I work on Fridays until between 7 and 9. So my mom has been picking her up. And then she drops her off after we go to church.
Mr. Chapman, is that acceptable that maternal grandmother pick up?
Yes, yeah, that's what we've been doing in the past anyhow. So
Miss Regan, as a courtesy, if anyone other than your mother picks up, Dad should know. Dad should know who's picking up the child.
He knows.
Well, if he knew, he wouldn't be asking the question.
No, he just stated that's what's been going on. He knows.
Okay, but my comment was, if it's changed in the future, your mother is not available, you should inform Mr. Chapman who will be picking up your 7-year-old. Okay.
Yeah.
Just courtesy. Okay, now what's your relationship with Michael Wingle? Is he out of the picture?
Yes.
Okay, because Michael Wingle should not be present during any of your parenting time.
He's not even present when she's not here.
All right, so if he stops over to visit, you can't open the door, can't let him come in if your child's there. Is that understood?
Yes.
Do you live with your mother?
No, with my father.
Okay, so who do you live with? Just yourself?
My father.
And your father, okay, all right. So rather than mother parenting time, you'd Friday after school, it'll be at 5 p.m. at the Speedway, correct?
Yes.
And parenting time, summer should be week on, week off. Presumably Sundays at 5 are usually a good time to do those exchanges. If in fact issues develop, either one of you can petition the court to modify this parenting time.
Okay.
All right, Mr. Chapman, do you have any questions for the court?
No. So it'll be every weekend. My only, this is gonna sound weird, but so this weekend I actually have a birthday party lined up for our daughter, over at our place. Is that acceptable to do this weekend, or do we need to make this go into effect right away?
No, let's address these matters today. So you're to have a pre-scheduled planned activity with your child.
Right. I wasn't sure how this was going to turn out. So
okay. Well, we can specify that this parenting time would take effect then on the following weekend. Is that any objection to that, Ms. Regan?
No.
Okay. Who met for the front court?
I did.
Good morning, Mr. Pratt.
Morning, Your Honor.
Can you add just a sense of this at this schedule? Your mom's parenting time will begin on November 1st.
Yes, sir.
Okay, well that'll address that. So child will be with dad this weekend since there's a planned activity with the child, and mom's parenting time will begin. You'll meet at 5 o'clock on Friday, November 1st. Understood for both of you?
Yes.
Yes.
We will clarify that in this order. If there's nothing further, the court will adopt this recommendation as modified, and you both mailed a copy. And good, effective communication is the key. There's enough challenges in life. Make it good for each other and your child. Make the exchanges pleasant so there's no drama issues. All right, that will conclude this matter. You can both zoom out. Appears that both parties are present. You're Heather McMullen, is that correct, ma'am?
Correct.
And we also have Manuel Medina present. Good morning to both of you.
Good morning, sir.
And Ms. Mullen, your objection makes reference to a referee recommend order of September 7th, 2024. The court could not locate that in the court file.
Your Honor, after discussion with the parties, I have determined there is no referee order. Ms. McMullen was trying to object to a tax offset notice she received from the state of Michigan. I did explain to her that she has filed this incorrectly and that she would have to file a motion to adjust. She is looking to adjust the arrears on the account. So there is no referee order. And I did explain to her that she did file this incorrectly.
That issue be addressed this morning, even though it's not before the court in the motion, or is there any discussion between the parties regarding the relief sought by Ms. McMullen?
There was a discussion, Your Honor, but unfortunately,
hold on,
unfortunately, the parties could not agree. The issue is when the last remaining minor child left the father's home to move in with the mother. Mr. Medina had stated, he did state that the child left in August and was willing to give a credit for the month of August. However, Ms. McMullen wants a credit for July and August. So we did not come to an agreement.
All right. Ms. McMullen, it seemed like you're best off to be coming to agreement today rather than have to come back to court on another motion. There's an expense to you and it's time off work for both of you. Sounds like the only issue is that you're disputing 1 month.
No, Your Honor, she was here in July, and I'm
just saying it was not probably before the court. I'm just suggesting, so we're not going to argue about that today. You got to file a motion. I was simply suggesting that now is the time to reach an agreement. We can have an order today. If you have an agreement, the court can adopt that agreement. But to absent an agreement, then you've got to file a motion. So the recommendation this morning is that this matter be dismissed because the matter was not properly filed in before the court. There is no objection to any referee recommend order. It's a tax offset in the state of Michigan.
I don't mind paying him, Your Honor. I understand that, but he had kicked her out. And honestly, she had moved her stuff here. I know she was here in July and in August, and she did turn 18 in August. So whether it was those 2 months or whether it was 3 months, he had kicked her out. So I was contesting the months that he had kicked her out, and I told him I would pay the other part of it and what I owed, but I was trying to settle it because I didn't know that I owed it, and I received this notice and I had paid on it. So I guess, I don't know, I was just trying to resolve the situation, and I thought I filed the right motion, but you know, because it said on—
This is not a motion. This is an objection to a referee recommend order. There is no referee recommend order, so the objection is inappropriate. So we'll note that nothing to be addressed by the court this morning. I'm simply suggesting that two of you reach an agreement this morning. Then you don't have to file a motion, incur a $20 filing fee, come back to court, take time off work. And if you have an agreement, we can reduce that to writing it in order today. But you don't want to discuss this anything further than Ms. McMullen?
Yeah, I don't know why he can't waive the 2 months that she was here.
You've talked with Ms. Patrick, and obviously you do not have agreement now. If you want to find some middle ground.
Yeah. I mean, I don't want to pay him the whole $189.
I understand. Is there some middle ground, Mr. Medina?
Your Honor, I'd like it to be clear that my daughter
All right,
was.
we're done then. All right, if I'm just asking a simple question, is there some middle ground? Do you two of you want to take a few more minutes to talk this morning? If not, then the court will enter an order and dismissing this matter. Ms. McMullen will have to follow a motion. Do you want to can you reach agreement in the next few minutes?
She doesn't want to pay, as I already gave her a month free.
All right, the hearing is dismissed. The court will send out an order, and Ms. McMullen, file your motion. It's I'm trying to save both of you some time. Be practical. Have a little common sense. Find some middle ground. Reach agreement. I mean, if you have
yes, I would like to do that, Your Honor, but she's the one that doesn't want to.
Okay. Do you want to talk to Mr. McMullen with Ms. Medina a little bit further? Ms. Patrick, we've got the parties here.
If you want to miss the 1 month, I'll just pay it. I don't want to deal with him anymore. Honestly, I don't.
Ms. Patrick, do you have a few more minutes to talk with the parties?
Yes, Your Honor.
Just give a few more minutes. If they don't have an agreement, then the court will simply adopt the recommendation this morning. And we can, if they have an agreement, we can reduce that to writing and be done with it. The court suggesting there's more important things in life.
Yes, I agree.
With Ms. Patrick, see if you can talk in good faith to reach the middle ground resolution this morning.
Thank you, Your Honor.
Thank you, Ms. Patrick, for being willing to confer further.
Brother, you need to join the breakout room.